In the world of high fashion, a single print can be worth a fortune. But what happens when someone else just copies it? Is that theft, or is it just business as usual? Well, this is the story of a legal showdown that asks that exact question, pitting pure art against industrial-scale production. So let's get right into it. Imagine this for a second. You're a designer. You sketch this incredible, totally original pattern. It's yours, right? But the moment that pattern gets printed on a dress and starts rolling off a factory line, who owns it then? And for how long? That's the riddle we're going to solve today. All right, here's our game plan. First, we'll look at a real-life designer's dilemma involving a huge brand. Then, we'll untangle the two different laws at the center of this mess. After that, we dive headfirst into the court case itself, reveal a super surprising rule called the 50 times rule, and finally, we'll ask the big one. Is this whole system even fair? Okay, let's kick things off with a real story, one that happened to one of the biggest names in Indian fashion. So, in one corner, we've got Ritika Private Limited. You definitely know them. They're the powerhouse behind the iconic Ritu Kumar brand. They're the creators here, and their whole argument is that their beautiful, hand-drawn sketches are original works of art. And here's where the trouble starts. They sued another giant brand, Biba Apparels. Why? They claimed Biba's prints were colorable imitations, which is just a fancy legal way of saying they were total knockoffs of Ritu Kumar's original art. Now, to really understand what's going on, we have to look at the legal battlefield. See, this isn't just about one law. It's more like two completely different rulebooks crashing into each other. First, there's the Copyright Act. This is the law that protects an artistic work, a painting, a sketch, a sculpture. And the most important thing to know about this, the protection is automatic. The second you create it, boom, you have copyright. It's all about protecting that initial spark of creativity. But then, on the other side, you've got the Designs Act. This protects a design, which is a pattern that gets applied to something, like a dress using an industrial process. So we're not talking about the original drawing anymore, but the pattern on the final product. And here's the huge catch. This protection is not automatic. You have to go and register it. Okay, so keeping those two clashing laws in mind, let's head over to the High Court of Delhi and see how this all went down. This pretty much sums up the whole fight. Ritika's argument was simple. Hey, our drawings are artistic works. They're automatically protected by copyright law. But Biba's defense? It was a bombshell. They basically said, nope, your copyright is gone. The second you mass-produce that design more than 50 times, you lost your copyright protection. And this is the detail the entire case hinged on. Ritika Private Limited had never registered their prints under the Designs Act. They were putting all their chips on that automatic copyright protection. A huge gamble, as it turns out. So now we get to the absolute heart of Biba's defense, and it all boils down to one little number. This is the legal twist that changed everything. 50. Just the number 50. What in the world is so special about 50? In a multi-million-dollar lawsuit, why does this one number matter so much? It sounds kind of random, doesn't it? Well, it turns out it was the key to the whole case. It's because of this little sentence tucked away in the Indian Copyright Act. It says that copyright protection shall cease. It literally just vanishes the moment an item with that design has been reproduced more than 50 times industrially. That right there is the 50 times rule. So the court's reasoning was basically a simple checklist. 1. Could the print have been registered as a design? Yes. Was it? Nope. 2. Was it put on clothes using an industrial process? Yep. 3. Did they make more than 50 of them? Oh, for sure. The result was unavoidable. The copyright that Ritu Kumar was counting on, it had vanished. And just like that, the verdict came in. The court sided with Biba Apparels. The lawsuit was thrown out. In a pretty shocking twist, Ritu Kumar's art lost its legal protection, simply because it became too successful. So what on earth does this mean for every other artist and designer out there? This case really leaves us with this giant question mark about where the law actually draws the line between art and commerce. Okay, so for all you creators out there, this is the big lesson. Your original artistic work, it can lose its copyright. It just evaporates the moment it's used as a commercial design, gets made more than 50 times unless you've gone and registered it under the Designs Act. That one step could have changed everything here. You might be sitting there thinking, well, why does a rule like this even exist? And that's a fair question. The whole point of the law is to draw a line in the sand. It gives a much shorter protection time for commercial designs because they're part of a fast-moving market, compared to the much longer protection you get for a one-of-a-kind piece of art. So, what this whole story shows us is this incredibly delicate balancing act. On one hand, the law wants to protect an artist's original idea, but on the other, it has to deal with the reality of a competitive commercial world. And in this case, the scales tipped hard toward commerce. Which leaves us with this final, really nagging question. Is it actually fair to limit a creator's copyright just because their art gets popular? Should an artist lose their rights simply because their work becomes a commercial hit? It's a fundamental clash between creativity and commerce, and as you can see, there is no easy answer.